Well, that sounded like I was done giving you the advocacy toolkit. I was, but there's more. Here's an addendum to lecture 5, recorded a few days after I did this binge of recording all 11 lectures for you. There are 6 additional things in the advocacy toolkit that I would like to add. Each of them can be very useful in a campaign. Each of them, one way or other, can be tied to a media strategy. Each of them can have short-term benefits and long-term benefits. And I've used all 6 of them at different times. First, let's talk about the possibility of getting a private members bill introduced. I will talk more about that in lecture 8, where I go through parliamentary strategies. But let me assume that we accept that it's really very unlikely that an opposition member's private members bill, or even a backbench government member of a legislature or parliaments introducing a private members bill, that it'll ever get enacted as is. Let's assume we know that from the outset. It still can be a useful strategy. It can be useful for several reasons. For one thing, there are times that a government will see a private member's bill, not necessarily agree that it will get adopted or passed as is, but they decide to grab something from it, that there's some seed of a good idea, incorporate it into a later government bill, or incorporate it into some non-legislated government policy. So, for example, I would use this if I'm trying to push for action in uh, in the education area, even if the government wouldn't adopt it as such on its face, but where they might come back with some education bill and include it among other things, or the government may direct some new policy to school boards and incorporate something that might have been in the private members bill. So that is alone can be useful, even though we know that a private members bill very rarely ever gets passed. And even though we know that before we even start, we also can use it very productively to build media attention and we'll talk a lot about media attention and media strategy in lectures 10 and 11. There I talk at length about the fact that the media don't cover issues, the media cover events. Well, the introduction of a private members bill is an event, and you can build a new strategy around it. It can also be used to, frankly, help embarrass the government. If you've been asking for action on something and they've not acted and not acted, having an opposition member who gets up and says, I'm doing this today because I want the government to act and the government's not acting, and incorporating in the government in a media, excuse me, incorporating in a media strategy, promoting that the idea that this is an area of systemic government failure. You've been asking for this for a long time. Why do we have to resort to this? Um, and finally, and a huge advantage of a private member's bill is it can help you get a champion in Parliament. It's always helpful to have a champion in Parliament, individual members of a legislature. In fact, the Access Alliance in New Zealand, later called the uh, uh, Access Alliance Trust or something like that, or Access Matters Trust, excuse me, eventually at one point had a committee of parliamentary champions for accessibility. They went to each party and got someone to agree to be part of this. It's not a committee of the legislature, but it just became a committee that they formed of champions that they could draw on. Any way you can do that, it can help. Let me give you an example of a private member's bill that we had introduced that it didn't ever get passed or get past first reading, but it was part of a bigger strategy. On the In June of 2015, it was just weeks before Ontario would host the Pan and Parapan American Games, kind of the precursor or the semifinals to the Olympics. And we'd been undertaking a major strategy to try to get the government to leverage its preparations to include promoting having more accessible tourist sites like restaurants and hotels. That's what a number of other cities do around the world when they have these games or the Olympics. Toronto and Ontario, unfortunately, was doing a terrible job in this area, was doing far too little. And we wanted to focus attention on it. So we also knew that there had been, and been in the media months before, there was a restaurant in Toronto, unfortunately it was closed, called the Signs Restaurant, Signs. And the Signs Restaurant was a restaurant that had deaf waiters. You place your order via sign language. It was very cool. Well, they put a ramp in front of their restaurant, which was great because they wanted it to be accessible. They want to practice what they preach for all people with disabilities. Well, the city of Toronto decided that this ramp somehow violated some city requirements and sent inspectors in ordering that they remove the ramp, tear out an accessibility measure. And we and others campaigned that the ramp was no problem. It wasn't obstructing anyone getting through. This is ridiculous. What a waste on public money. The city should be doing more to become accessible rather than using its resources and public money to oppose a restaurant trying to be accessible. Um, so what did we do? We got an opposition member for the New Democratic Party in Ontario, named Percy Hatfield, to then introduce a private members bill which simply banned municipalities from using public money to oppose measures on accessibility. So we would have made what happened with the Signs Restaurant illegal, or what was attempted to happen with the Signs Restaurant illegal. And this came right in the middle of our campaign to get the province to do more to ensure accessibility of tourist services like restaurants in Toronto. So the private members bill was part of a bigger strategy. Now, my second new strategy, or pardon me, second strategy I want to add to the toolkit is campaigning for public hearings for a bill before the legislature. Whenever a bill is introduced into the legislature to become a law, whether by the government or the opposition, there could be an assignment of the bill to a committee of the legislature and public hearings, but there doesn't have to be. We talk more about this in lectures 8 and 9, but suffice for present purposes to say the government has to decide they want hearings. And so one of the things in our toolkit, one of the tools in our advocacy toolkit is to mount a campaign to try to convince the government to hold public hearings. And if they're going to hold public hearings, if possible, to have them held not only at the legislature or in parliament, that they have them travel, go to local communities around the province or whatever, wherever you live. Why do this? There are multiple benefits. Number one, it helps put pressure on the government to listen to us, our, in this case, our disability community, but whichever social justice community it is. It helps get media coverage if there are hearings. It helps us to have a say before the parliament or legislature. That's what lecture number 9 will focus on. But as well, it helps draw in members of the community to get involved in advocacy on the bill. After all, if they hear about the bill early enough and they think it's important enough, if we can get them active by saying, hey, I want to have a say in this. Well, why don't you write the government and say, we got to have hearings so I can have a say in this. This helps mobilize people earlier on in the legislative process. It helps alert the media, if you publicize your campaign for hearings, that this is a bill that the public wants to be heard from. And that in turn helps mount pressure on the government to agree to hold hearings. In one particular case, back in 2006, the Ontario legislature introduced a bill which was quite controversial, and I and the coalition with which I'm connected, the Accessibility for Ontarians with Disabilities Act, were vehemently opposing it. We lost this battle, but it was a bill 107, which was aimed at changing the way human rights or discrimination cases would be enforced. Instead of going to a public law enforcement agency to investigate and litigate these claims, the Ontario Human Rights Commission, it would leave it to you to bring your claims to the Human Rights Tribunal yourself. You'd have to investigate them yourself. You have to litigate them yourself. You wouldn't have a public law enforcement agency to investigate and litigate them. Now, the Human Rights Commission have been under a lot of criticism for being too slow and taking too few cases. I don't want to get into that whole debate, but in any event, it was controversial. There were those who thought the reform would be good. There were those who thought it would be bad, and I and my coalition were among those who thought it'd be really bad. So we not only pressured for there to be hearings, but we asked the government to commit that anyone who wants to be heard would be heard. And eventually the government committed to this. And then we were very involved in lining up, working with other natural allies in the community. We collectively got a number of individuals and organizations to apply to be heard at the hearings. It was quite a lineup. We also did, I took part in workshops to help train people who might appear at these hearings on what to say and what to expect. Well, this became really important, not only to mount the pressure, because you could then emphasize how many presenters were opposing the government's bill, but the opposition of the bill was getting so much attention. The government did something rare. They invoked closure. They actually, and this was under the Liberal government of Premier Dalton McGuinty, the same premier who the year before had led the enactment of the Accessibility for Ontarians with Disabilities Act. Well, they invoked closure to cancel hearings that were already scheduled. There had been several days. There were some who spoke in favor of the bill, but there was so much criticism of the bill, the government decided they didn't want any more hearings. And the fact that we had campaigned for hearings for all, and we had campaigned with others to get so many people to sign up for the hearings, led to quite a debacle when the government canceled these. It became the lead topic in question period. It led to both opposition parties, which normally don't agree on very much at the time, the Conservatives and the New Democrats, who are kind of Labor or Social Democratic Party, to argue in unison that what the government was doing was bad. In fact, it was such a ridiculous situation that the government had placed ads in newspapers inviting people to apply to these hearings. And in the same day, there was news coverage that the hearings had been canceled. I guess they couldn't pull those ads in time. So campaigning for there to be hearings and for there to be for as many people as possible to sign up to appear at those hearings, and for commitments that everyone will get heard, a commitment that was violated by this closure motion, can be part of a much bigger strategy. Now, in this case, it was important that we mounted it. Sadly, it ultimately failed. The bill passed, and has caused what I believe to be long-term damage to human rights enforcement. But you don't win every battle. It's important to know what's in your toolkit. Now, these first two elements or toolkit tools both relate to the legislative process itself. More on that in in lectures 8 and 9. But let me turn to a third strategy, which is independent of all of that. And that is the tool in your toolkit is the use of freedom of information legislation. In a number of jurisdictions, including Canada, we have legislation providing for freedom of information, federal legislation for the federal government, provincial legislation for the provincial government, and provincial legislation for broader agencies of the federal government or in the provincial sphere, and also for municipalities and school boards. Now, they don't guarantee that absolutely all information is public. They create certain rights of access, and then they create a series of exemptions that a number of people, including myself, think are too broad. How do you use it? Well, you formally apply. You submit an application in Ontario, you got to send $5 with your application. And in the application, you identify what you want, and then um, it goes to the government. And then there's a freedom of information officer designated within each major government ministry or department or whatever. They go through it and they get back to you and they will tell you either if they will give it to, if they found anything, if they'll give it to you, or they may invoke an exemption and say, sorry, we are not required to disclose this because of an exemption we think applies. Or they can say, we'll give it to you, but there's a fee for it, for searching for it. And the fee depends on how much time is involved in searching. If they can find it immediately and quickly with no real extensive search, they can't charge a fee. If you don't agree with the fee, you can ask them to waive it if it relates to there are certain powers for the government to waive the fee. Um, and that depends on reading that legislation to see what's exempt from fees or when they can waive the fee. And if you're not happy with any of their decisions, either them saying they didn't find anything or invoking an exemption you didn't think would apply or charging you a fee that you don't think is appropriate or refusing to waive the fee that you don't think is appropriate, there can be appeals. Again, you have to look at the freedom of information legislation to see what it says. In Ontario, for example, there's an appeal to an agency called the Information and Privacy Commission. Well, now, why do you do this? Why would you bring a freedom of information application? It's smart first if you want something, not to do the formal process, but just to write and ask for the information. Or phone and ask it. If they give it to you, they give it to you. Then you don't have to go through $5 or whatever they charge you. You don't have to go through this bureaucratic process. And in fact, you may not even have their freedom of information officials involved. If you're in a meeting with someone and a government official and you say, can we have that document? And they go, yes. They give it to you, you got it. So the first thing to do is ask for it. You can you'd resort to freedom. I've resorted to freedom of information requests when they've refused to give it, when it's really important, and I think we've got a good case under the legislation for getting it, and it's also if I think it's worth the effort. Why do it? Because you need the information. Why do it? Because you can build a story out of a media strategy if they refuse to provide the information, and it can shine more light on excuse me, on the government's failing to work cooperatively, if they are failing to work cooperatively, and if it's information that they should have made public and at no cost. Another reason to bring a freedom of information application is to essentially put the pressure on the government to take more action on an issue you're dealing with. If the very fact that you've had to resort to it and that they won't give the information over can cast them in a troubling light, show that they're being recalcitrant rather than constructive in working on the issue. And it can help ultimately get more media coverage on the overall dispute, the overall issue. In lectures 10 and 11, we'll talk about getting media coverage, but a story could be the government's not only not doing X, but won't even disclose information about what they think they're doing or planning or said they do or whatever. Let me give you an example, and it's quite a huge example of how the freedom of information legislation can make a real difference. Not every time you do it does it make this difference, but this is a real success story. So starting in 2013, and shortly before that, the Ontario government had to start enforcing the Accessibility for Ontarians with Disabilities Act Customer Service Accessibility Regulation for the private sector. And we were worried that they really weren't doing anything. So I wrote the minister responsible for its enforcement and asked how many, what are they doing to enforce it, and what do they know about compliance and so on. And the minister didn't answer. And so we first started trying to get pressure on them by running a campaign on Twitter. How many days has it been since it's been 300 days or 200 days or whatever number of days it was since the minister was written and still has an answer. They promised effective enforcement and won't even tell us what they're doing. And that count went up, and that became kind of a form of advocacy or pressure. And then eventually, when we weren't hearing anything, I filed a freedom of information request. And then what the government came back with was a statement that, yes, we've got, we can answer it, but they were going to charge a couple $1,000s. Well, I explained that the AODA Alliance is an unfunded coalition, has no money. And we're a social justice organization, and so they should waive their fee. And they initially refused to. But then at the end of October of 2013, an opposition member, Sherry DeNovo, got up in question period and blasted the minister for failing to just provide this information. And the next day or two after this, the Toronto Star actually ran an editorial blasting the ministry for trying to charge us a fee for getting access to this information. And by the way, we argue it was information the minister's office should have anyway, and so they should be able to fork it over. The minister's responsible for enforcing the act. They made promises of effective enforcement. Why should they have to spend a couple $1,000s worth of public service time to find out what the heck they're doing to enforce this law and the levels of compliance that they should have at their fingertips? Well, that had been the focus of the question period question and then the editorial. Well, this forced the government, embarrassed the government enough that they said that they would give me the information without charging the fee. And I then got the information, and it showed that there was massive known non-compliance in the private sector. The government knew about it. It showed that they had done pretty much, they'd issued no compliance orders. They were doing virtually nothing to effectively to enforce in the private sector. And I also revealed that they had budget still on hand in the department responsible enforcement. They were under budget, not over budget, so they couldn't claim, hey, we can't do any more, we don't have any money. So I fed this information to the Toronto Star for an exclusive, and it came out as a story. And it got a lot more prominence because it was an exclusive and because this information was forced out of them through this freedom of information process. And the government promised they would do better, and they committed to a new strategy of a certain level of enforcement. It wasn't enough, but it was better than we'd like. Now, that alone is a good story, but this saga continued. 2015 rolled around, and in the June of 2015, it was the 10-year anniversary of the Disability Act being passed. And there was going to be a lot of attention by the government to that deadline or to that anniversary, and we were doing the same. So I wrote again to ask, hey, can you just update us on the information that you gave us back in the fall of 2013? Basically the same information, more or less. And remember, they gave it to me, ultimately no charge. Well, the government went back and wasn't answering. So I filed a second freedom of information request. And I asked for the same stuff, maybe somewhat more, but not enormously more. And they came back after a month or so and said they were going to charge, I think it was over $4,000. It was a substantially greater fee. And I asked them to waive the fee for the same reasons that they waived it a year and a half earlier, and they refused. They gave me a few pieces of information that they said they could give without having to search for it. But anything else, they said, you want it, you got to pay for it. So I did something that I had not had to do before. And it's pretty, and of course, we go public with the fact that, hey, they're refusing they're trying to charge more money after, in the exact same circumstances, a year and a half or 2 years ago, they gave it to us for free after they were embarrassed by an editorial in the Star. Well, what happened? I had to file an appeal to the Information and Privacy Commissioner. So I did. And $75 to file it. Normally, the Information and Privacy Commissioner has paper hearings. In other words, you do written submissions, the other side does written submissions. There's no hearing in person. However, I found out it's not in the legislation, but in any detail, but I found out from talking to people who practice in the area that you could ask for an oral hearing. And I did. Why did I do that? Two reasons. One, I wanted to have a face-to-face chance to persuade the adjudicator. It's never the same when you just file it in writing. That's just traditional lawyering. But number two, I wanted a public event where the government had to come out and justify what they're doing and invite the media to attend it. Well, a hearing did come up uh, months later. It was in person. The media, there was a journalist covering it, and it was amazing. In walked five lawyers for the government, five lawyers. So I looked at the adjudicator and said, this is to save $4,000. They need to send five lawyers against us. And it was me who was there as a volunteer and my pro bono lawyer helping me out. Well, ultimately, the adjudicator, uh, uh, um, and by the way, up to that hearing, they would not agree that the AOD Alliance had no money. They had no basis to say we had money, but they didn't have any basis until they had to file written argument with the Information Privacy Commission. Then they suddenly filed one saying that they conceded that we have no money. I mean, this was beyond ridiculous. Ultimately, the adjudicator rendered reasons that said that they had overcharged, that their fee was unreasonably high, and they said certain of the things we should get at no charge, and other things they reduced the charge ultimately very substantially. So I never paid anything, but we did get the information that was provided for free. Again, went to the media and again got a Toronto Star editorial blasting them for having put me and my coalition through this. So this is an example of how, at its fullest, the freedom of information legislation can lead to policy changes, can lead to major media coverage, and can lead to potential results. Does that happen every time? That's my best example. Lots of times, nothing like that. Let me offer you a practical tip or two about how to do one of these applications. At least these are the strategies I use. Number one, try to ask for the least you have to. If anything, I've probably got examples where I've asked for more than I should have. The reason being, I mean, maybe that I was, in each case, I don't ask for anything unless I genuinely feel like we're entitled to it. But if you need only certain things, absolutely just stick to those things. The more you ask for, the more they can potentially start invoking exemptions, and the easier it will be to defend it than if it's only a shorter number of things. Now, my past practices, I could have learned that lesson earlier. The next thing is ask as clearly as possible for very specific things. If you could say, I'm asking for document X, it's dated within the following range, and it should be in the office of Y, what you're doing is saying they only have to search in those places and for those dates. So they can't start charging you for much larger search times. The next thing I do is I offer to meet with them if they want, even on a without prejudice basis. And I put this offer in the freedom of information request to say if you've uncertainty about what I'm asking for, my aim is to minimize the search time and to make it easy as possible. Feel free to talk to me. And if there's any difficulties with my requests, I'm happy to narrow them. And also, I want it clear that if there's some things you could give me for free and other things for which there would be a charge or an exemption, I want you to just give me the stuff that you agree is free now and don't hold it up pending possible arguments over exemptions. And that kind of strategy to be both cooperative and to offer to work together can only help and can never hurt. Now, let me get on to the fourth new strategy in my toolkit, and that is mounting a campaign during an election, a by-election. Now, for anyone outside Canada who may be watching this, what is a by-election? If there's a government that's been elected in a general election, and if a member of the legislature or House of Commons resigns or dies or whatever, then within a certain amount of time, the government has to call a mini election just for that riding. They sometimes bundle them a couple of by-elections, and they're called by-elections. And so there's an election campaign to be elected for the rest of the term of that government, or pardon me, the next, actually the term of the legislature, not the government. And each party will nominate candidates, and then they may have all candidates debates, and then ultimately there will be an election. Now, a vote, but the vote's only in that riding. Now, you might wonder, why do this? Often, rarely does a by-election ever swing the outcome of who governs. Typically, the government is governing with enough seats that even if they lose one seat or gain one seat, it won't make a difference, no matter what. However, by-elections are useful for us for multiple reasons. The strategies I use are the same as those I've given with respect to any election blitz, coming up with an action kit, making requests of the various parties for commitments, in this case, the candidates, publicizing what their commitments are. We don't endorse or oppose any particular candidate, but we want voters to know what their different positions are on the issues, and raising these kinds of issues at all candidates' debates with the media or however you can. Why do all of this, even if the outcome isn't going to change the outcome of the government? Well, the same way that we don't try to elect or defeat any government, we don't care whether it affects or doesn't affect the outcome of the government. It's still a useful platform for us. We're basically mounting a parallel advocacy campaign using the election as our platform. It has several purposes. Number one, it certainly helps put pressure on the parties to be ready to keep coming up with commitments or to refine their commitments that they made in the last election. I don't want them to think that we go to sleep between elections. The next thing it helps is it's important to make these candidates become alive to our issues. Just because they're running for office doesn't mean they know anything about our issues. And a by-election where they're expecting questions from the public or have to answer these kind of inquiries puts the heat on them to learn about these issues. It also helps build potential allies, later champions in the legislature. And there are times at a by-election that somebody gets elected who may be, just elected from one community, doesn't get a cabinet ministry, may not make a difference. Others may end up becoming a cabinet minister, or if and could make a difference, could make a lot of difference. And even if they're not a cabinet minister, they could become a champion for us within their political party. So having those relationships initiated when they care the most about public opinion during an electoral process really matters. And finally, it's a helpful way to focus the media. Again, whatever we do, we try to leverage it to get media coverage when we can. Next strategy, number 5, is mounting an accessibility campaign during a party's leadership competition or campaign. In Canada, both federally and provincially, if a party leader steps down, the party chooses who their next leader will be. How they do that, what their actual process is governed by the party's own internal rules and constitution. But it usually stretches out over a period of months. Various people announce that they're going to run for party leader. There may be, and typically are, some televised debates and other events where the candidates compete with each other. And then there's a convention or some sort of online voting followed by a convention where the decision is made. Here again, as nonpartisan, we don't support any party or oppose any party, but we also don't support or oppose any candidate for leadership. However, what we do is write a letter to the candidates for leadership, list commitments we'd like them to make, and ask them to make these commitments, and then make public the commitments they make and compare the commitments from the various leadership candidates. And we've done this in a number of circumstances. There are times when all the candidates answers, there's time when some of them do, there's times when none of them do. Um, the advantage of doing this tracks the points I've been making earlier. You can get media coverage on it. That's useful. It can also help make journalists become alive to the fact that this is an important issue in a leadership campaign. But also, the candidates running for leadership may well not have thought about this as an issue that they should be addressing their mind to during the leadership. This uh, uh, does that early on. It can start helping build a relationship if they win as leader that you need. You want to be able, after they win as leader, to say, hey, during your campaign for leadership, here are the commitments you made to us. Um, they are the most needy of support when they're running for leadership. Now, we don't offer our support, but on the other hand, they're more willing to give commitments then than they may be later on when they are in office and then they're becoming more cautious. Not that they're reckless beforehand, but they may be more kind of nervous later about making commitments on our issues. And another thing that is important when you draft your requests is building commitment requests that will actually reinforce your relationship. When we make these requests, we don't just ask, hey, if you're elected leader of your party, will you support the following important issues on disability rights or accessibility or whatever it may be. We'll also include, and when I've written these, I will make a point of saying, we want to have a relationship with you. If you become leader, will you agree that within X weeks of becoming party leader that you'll meet with us and that you'll have regular meetings? If you are elected premier, will you agree to meet with us on a periodic basis? Um, and some have made these commitments and lived up to these commitments. That's really important because after they're elected leader, if you haven't asked these things in advance and they haven't made the commitments in advance, they may be scrambling around with so many other priorities that you are not going to have much of as good a chance of getting to speak to them. And you never know how the dice will roll on these things. In 2012, the then Premier of Ontario stepped down, announced that he would be stepping down as leader, Dalton McGuinty, and the Ontario Liberal Party started a leadership race. And one of the candidates for leader, Kathleen Wynne, eventually won and became premier, and then got elected premier in a general election the next year. Well, while she was running for leadership, um, she knew of our issues, and I had met her before, but very relatively um, few number of times. And uh, during the liberal leadership campaign, it happened that each of the candidates was being separately interviewed, I guess, on different days on Ontario's then flagship public affairs program, TV Ontario's The Agenda with Steve Paikin. And on the exact day that Kathleen was interviewed, I had also gotten an interview scheduled. I didn't coordinate it for that day. I didn't see her at the studio. They were recorded at different times. But when they went back to watch the show that night, her team and the other teams of the other candidates running against her um, would have watched the program and seen not only her interview, but my interview for my coalition. And sometimes, like I said, the dice just roll in a way that is extremely helpful. Of course, these commitments are important if someone does win after they're elected to hold them to it. And we will, in the case of, for example, Premier Wynne, on many occasions afterwards went to her on her promises to us when running for leadership. Some of them she kept, some of them we claim she wasn't keeping, but that's all a product of getting those commitments when we did. So let me turn to the sixth and final strategy I want to add to your toolkit. Sometimes there's a one-off legislative or legislated process that gives you a chance to have a really important avenue for raising your concerns. Under the Accessibility for Ontarians with Disabilities Act, there is a requirement that 3 years after the law went into force, and then, or 4 years after it went into force, and then on a formulaic schedule, or a schedule that is formalized in the legislation, I should say, the government's required to appoint an independent person to review how the legislation is doing, to consult the public, including people with disabilities, and to render a report to the government, including recommendations where there could be improvements. As I record this, there have been four. In 2010, the first one was released, 2015, the second, 2019, the third, and 2023, the fourth. The next one is in the future. And in each case, we have used this as a platform, not only to have our own say, but to press for others to get as much of an opportunity to do so as possible. Let me give you an example, or let me give you an illustration of the kind of steps we take. So before the person is appointed, we will remind the government that their appointment deadline set in the legislation is upcoming. And if in one case they weren't appointed on time back in 2013, I believe it was, and we put a lot of heat on the government to get the appointment made, and the failure to have done so was, I believe, got some media coverage and certainly got public attention. We do not put names forward of who should do it, but what we will do is articulate the principles that we say should apply, what the person should or shouldn't have in their background to make sure that they will be fair and effective in doing an independent review. Once they're appointed, we will reach out to the person doing the review and offer to do anything we can to help them. We will give them recommendations on how to conduct their consultation in a way that best ensures that people with disabilities can be heard. And with a number of the reviewers, that's involved a number of conversations or meetings, and offering to help by saying, listen, we've got a very strong network of communication with the broader disability community, and we're not the only way you can reach people, but we want to make sure you get your invitations out and for meetings and chances for input and so on. We will provide action kits or tips for the public, urging the disability community to take part in the consultations, and when there are consultation meetings, publicize them, let them know. But we'll also offer tips of what's worth including in your presentation. Of course, people are free to say what they want, but as with any other brief, we want to use our brief as and our efforts to help people get a chance to have a harmonious message wherever possible. We, in each case, have written a very substantial brief. These are all up on our the AODA Alliance website, aodaalliance.org, /briefs. I'm including some of the resources for this lecture, but in any event, we'll follow our practice of first publishing a draft brief and then a final brief. What our briefs are, if you read them in detail, is like an entire history of what's gone on over that period of time under the major areas: enforcement, creating accessibility standards, educating the public, and so on, the major domains where government needs to act. And we make proposed detailed findings that the that the independent reviewer should make, and then we identify recommendations that they should make. And I will tell, I think it's fair to say that in each case, the reviewer relied on our submissions, of course, as well as those of others. But our submissions have, in each case, had a, I believe, significant impact in both the findings and the recommendations and the focus of these reviews. When they're released, we immediately make them public. We issue a news release giving a quick summary of what they've had to say, and then we have published more fulsome responses to them afterwards. We'll then press and advocate to the government that they listen, not only act on them. If there's any recommendations we don't agree with, we explain and say why. But we will, when the government, or if the government eventually comes out with an announcement of what their response is or what they're prepared to do, we're all over that with whether it's sufficient, and if it's not, why. We also use the tactic I've mentioned a couple times, the countdown or count up. In the case of 2019, a blistering third independent review report was delivered by the late David Onley, former Lieutenant Governor of Ontario. He was absolutely, I said blistering, I can't think of a stronger adjective, hammering the government over, successive governments over doing a poor job of implementing the act. He used words that we've quoted over and over, talking about how the implementation of the act or progress on accessibility has been glacial. How Ontario is still full of soul-crushing barriers facing people with disabilities. We've quoted that over and over, but we also have run a count on Twitter and other social media and in our AODA updates from time to time of how many days it's been since the government received the report and has not responded to it with a comprehensive plan. And so these efforts help mobilize people out there. They help focus media attention, like all these other strategies, but they also become a platform for future advocacy after the report is rendered. And for anyone who wants to know what we've had to say, or how things have gone, or what needs to be done differently, if they look at our briefs that we've submitted to successive independent reviews, they're a major resource. They bring together the information that is set out in bite-sized components in our regular updates here, concentrated, organized, and synthesized. So quite a toolkit. This adds to the toolkit. Now let's talk, as I said earlier, about how to go implement this toolkit in dealing especially with the government and elsewhere. Thanks for listening.